Now that's the end of my part of the presentation, and Dr. David Clements, who's a law professor and an attorney, is going to take over from here.
Thank you. Quick background for me on why I'm here. There was a time like Ms. Logan that I had all the credentials. I wasn't canceled. In fact, in 2016, I was the prosecutor of the year. I've done over 1,000 evidentiary hearings. I've done over 160 felony jury trials. I've got to lead trial teams, and I've gotten 8 first-degree murder convictions. The 3 years that I was a law professor, 2 of the years I was nominated for the most prestigious award. I won it the last year, and I was terminated the very next day because I challenged the COVID mandates and I talked about elections. So as a lawyer, I'm very well versed on how evidence is supposed to be presented. And the reason why I have rallied to the cause of the Hawk brothers is that this is an open and shut case. In my independent legal opinion, the filing from Ruby Freeman and Chamos was a frivolous filing. In fact, we could put the issue to rest immediately about whether or not those ballots were jammed, and this is how you can determine it. The Dominion system, which they use, creates a ballot image of each ballot and a corresponding secure hash algorithm. It's a SHA file for each ballot. The SHA file is a verification file. A ballot image and a SHA file together allow you to tell when the ballot was scanned and whether the image was manipulated at any time after it was scanned. Who controls this? Not the Hawk brothers. At any time over the last 3.5 years, these files should have been preserved pursuant to federal law and state law, because there's a 2-year legal requirement to hold on to all election records. So this is very, very important. Now, why haven't they? Or why haven't we able to obtain these files? Through malfeasance, negligence, who knows? Of the approximately 168,000 ballot images and SHA files, only 16,000 have the complete image-SHA pair. The other 150,000 ballot images are missing their SHA verification files, and there's evidence in the image metadata that the images were manipulated as well. Conveniently, for Ruby and Shay, there's no pairing.
How do you know this, Lee?
Because we've worked with experts that actually had a filing in a federal court matter with experts. It's not the Hawk Brothers cases, but I've examined the pleadings and the expert reports. And so this is something that's been litigated, and and we looked at the actual timestamps. So the 16,000 that we can vouch for weren't created during this 10 o'clock at night till 2 in the morning time period. It doesn't exist. My point is this: it should exist, and that should put the issue to rest.
What is the evidence in the image metadata that you say exists, that images were manipulated? What are you talking about there?
Oh, well, in the technical aspects of it, it's each of your tablet images, your scanners, you have system log files that you can retrieve. So there have been system experts. I'm an attorney, so I kind of have to evaluate what they say and disclose to you what their findings are. But their findings are that you didn't have the pairing, and so they can take it to the bank that you don't have the verification file, and they should under the law. So with this, narrowly focusing on just 10 o'clock till 2 in the morning, and the very, very limited claim produced by the Hawk brothers, which was you saw ballots being scanned 3 times. Their lives have been upended, and they're on the verge of bankruptcy. So that's why I'm here. So now let's talk about the legalities of this. But before I do that, let me actually give you a little anecdotal evidence, Laura, because you actually brought something to my mind. I was a part of an audit team that did audits in 8 counties in New Mexico. We use, like Dominion, like Georgia, Dominion machines. And we scanned ballots. We actually, as part of our audit, we scanned ballots. We chose the same exact scanners that were used in Fulton County as part of our test audit. There were times where we had ballots that jammed. And that process that was described by Jim, where people retrieve and clean out the rollers and have to zero out an image to make sure you don't have duplicate files as part of your record, we had to deal with that same issue. And it's a tedious process. It takes time. You'll notice through an observation of the scans from Ruby Freeman, there was no such process where someone stopped, looked at the rollers, was pulling out paper. And so from a standpoint of just using your common sense, we find that very, very problematic. And that's why the Shaw files are so important, because we don't have to take the word of a public official that it was jammed. Get over it. There's a way to check that. So let's get to the law. The case that governs free speech is the New York Times versus the Sullivan decision. And it's supposed to afford the press protection to have a conversation about things that are important to the public. And it creates a very, very high barrier to collect damages from journalists. Because the First Amendment's important. In fact, one of the main holdings is that there's a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials.
Can you state again which case that is?
That's the New York Times versus Sullivan decision. It is the benchmark case that every lawyer that studies defamation has to understand. And so this should apply to the gateway pundit and the Hoff brothers. Now here, when we talk about public officials, it's important to understand that Ruby Freeman, whether she's a contract employee or not, or Shamos, were agents of the state. So they were de facto public officials acting in the interest of the state of Georgia and supposed to be serving the public trust for voters in Georgia. Now, this is the standard under the same case decision. Basically, you want to be able to prohibit a public official from recovering damages for defamatory falsehood relating to his or her official conduct unless he or she proves that the statement was made with actual malice. That is, with knowledge that it was false or with reckless disregard of whether it was false or not. That shows you how high the standard is, that the law even makes allowances for false statements if they were made in good faith. We just heard from Mr. Hoff that they stand by the reporting. And you saw video evidence that shows here they're telling the truth. So, and when we talk about actual malice, it doesn't mean that they have to have ill will and be mean about it. It's just a legal standard that they had to be reckless. And the hallmark of knowing why they're not reckless is because 3.5 years later, 4 years later, nearly, that video still stands up to the test of time. You can't find actual malice here. Now, Ruby and Shay might want to push back and say we are not public figures. They could say, we want nothing to do with this. And there's a case by the name of Gertz versus Robert Welch where we can make findings of someone being a limited public public figure. And this is a person who has thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved. Now, whether Ruby or Shay meant to be thrust into a controversy, there was surveillance footage that captured their actions at night, and they were thrust into this controversy.
Could you argue that the act of suing people thrust them into the controversy?
You could certainly argue that, but as Jim mentioned earlier, there's already widespread reporting from November 3rd into December when they actually published their stories where people were talking about these actions. So it was a controversial, there was controversy surrounding State Farm and whether or not there's a water main break and all the other things. But a person can become an involuntary public figure as the result of publicity, even though that person did not want to or invite the public attention, I think Ruby and Shade, my independent legal analysis, would fall into that category. Of course they didn't want attention. That's why they were scanning ballots in the dark of night. But the law has a place for this. So here's what the First Amendment is supposed to do. It presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many, this is and always will be followed, but we have staked upon it our all. The point here is to have the ability to have our reporters ask questions and not be destroyed. That's really what this case is about. And this is actually an innocuous example. When you really think about all of the evidence that's out there, video surveillance is some of the strongest evidence that we have. Now, we have done analysis of Dominion tabulators through audits across the country. These folks were sued, and there's not been an examination of the source code on how the Dominion machines operate. That is unthinkable, that someone could devastate someone's lives and not even check to see if the source code has been is a trustworthy code.